Hello, my name is Ryan Krupp, Adjunct Professor of Constitutional Law at Missouri Baptist University. And this video is going to go over one of the most important constitutional law areas, especially as it relates to criminal justice, and that is the Fourth Amendment. The Fourth Amendment of the United States Constitution protects against unreasonable searches and seizures, which applies specifically to law enforcement, and then it is covered under the Exclusionary Rule, meaning that if the law is violated, if the rule is violated, then any evidence thereof will be excluded from trial. Now, an overwhelming majority of people do not know the method by which the evidence is excluded from trial. They maybe have some idea, but they just think, well, it'll just get thrown out. Well, how does the evidence get thrown out from trial if there's no legal search and seizure? The answer to that question is the defense attorney will file a motion to suppress the evidence. Now, most law enforcement, and in fact most lawyers, do not know what happens when a motion to suppress is filed. But here's how it works. A defense attorney files the motion to suppress the evidence, and then it is up to the state, as in the state or government, could be the federal government, has the burden of proving that the motion to suppress should be overruled. So even though the defense files the motion and says, hey, judge, you should throw out this evidence because there was an illegal search, the government is still the one who has the burden to say, hey, you shouldn't throw it out because the search is valid. Unlike some other court hearings, the motion to suppress is like a mini trial. There are actually witnesses, so law enforcement are oftentimes called to the stand to testify in these motions to suppress. When I was in the prosecutor's office, I had the chance to defend many motions to suppress, meaning that the attorney would file the motion and I'd say, I'd have to bring officers to the stand and say, Judge, the motion to suppress should be overruled, and here's why. I'd have to put them on the stand and explain and go through the search. Now, on the other hand, I've also filed many motions to suppress the evidence from the defense side. Now, one thing that I noticed when I was doing it from a prosecution side and having law enforcement officers come in and testify is the first thing a law enforcement officer would say to me is, why are we here? The person is guilty. I found drugs or whatever illegal evidence on them, and so therefore, what do they have to fight about? Well, they may be guilty. They may have had drugs or contraband or something else, but the truth is that the government has the burden of upholding that conviction, and to do that, they have to have a legal and justifiable search. So we're going to talk about how not to get your evidence suppressed in an illegal search. So right off the bat, it's very important to know that there are three types of police encounters that are covered by the Fourth Amendment of the Constitution of the United States. The first type is a consensual encounter. The defendant, provided you with the opportunity to search them or approach them. That is to say, for instance, someone comes up to you as an officer and says, officer, please come here, right? Or, hey, officer, I want to tell you something that's going on. That's a consensual encounter from the beginning, all right? The second type of police search starts with a search of an incident that requires reasonable suspicion. So if you don't have the consensual encounter, the second step is you have some sort of reasonable suspicion to start to investigate a crime, and we'll kind of go over that. Now the third step, the third type of encounter is an actual arrest, which requires probable cause. So within those three levels, you have consent, you have reasonable suspicion, and you have probable cause. Those are the three standards, and they start with the easiest standard to meet, and then they go down to the hardest standard to meet. So consent, anybody that consents to anything is always going to be admissible. They always gave you the evidence. So it's a low standard. The defendant would have to overcome a large presumption there to say that something was not consensual if they're the ones that provided the evidence. All right. Reasonable suspicion, that's a little harder. You have to have specific, articulable facts to make a stop. All right. There's some examples of that, and we'll get through there. Probable cause is that step further than reasonable suspicion. It can't just be some articulable facts that make you think that crime's afoot. You really have to make an arrest based on facts that show that it's fairly likely that a crime is being committed right in front of you. Consent is fairly self-explanatory, so we'll kind of move to reasonable suspicion, which is a little questionable. People always tend to have a little bit of a hard time with the reasonable suspicion. The reasonable suspicion has to be based on specific articulable facts. right? So that car looks suspicious. That's not reasonable suspicion. Is it reasonable that there's something going on, that crime is happening? Well, it's sitting in the parking lot. All right. Is it illegally parked? Have you seen multiple people make a transition up, back, and forth to it and exchange money or something like that? That would make you think, all right, maybe he's selling t-shirts, but more likely he's selling drugs. So it's important to know that your approach has to be justified upon inception. You have to be able to say, I reasonably believed that there was crime afoot, and here's why, blank, blank, blank. Now, this comes forth in a case called Terry versus Ohio. A lot of law enforcement officers use it to justify what's called a Terry search. So that's a pat down of the outer clothes, and we'll get there. But what's important to note about that is the officer in that case could see people essentially casing a jewelry store. They're walking back and forth, looking around, outside for hours, and it looks like they were appeared to be casing the place. If you have reasonable suspicion to make the stop, the next thing you'll need before you make an arrest is probable cause. In the Terry case, there was an allowed for a pat-down for search of weapons, and what they found was an illegal weapon on the person. There was probable cause that the person was committing a crime. It was fairly obvious because it was an illegal, unregistered weapon, so they were able to make that arrest. You cannot make that arrest until you have probable cause. That's a step further than reasonable suspicion. Now, important to know that once you make an arrest, you can make a search incident to that person's arrest. You can search their clothes and or area immediately surrounding their body. So what am I saying here? How do you not get your evidence suppressed? It's clear. Start from the beginning. Do you have consent? Can you get consent? All right. Do you have reasonable suspicion? Start from the get-go. If you don't have reasonable suspicion to approach a vehicle, for instance, do not approach the vehicle without the suspicion. Be patient. If you think something is fishy or suspicious, something will probably happen. Give it time. The police report is crucial. The videos, the dash cam, the body cam, they're crucial. You have to get down what you're seeing as suspicion. If you're seeing something that's suspicious and your body cam isn't picking it up, narrate. You have the ability to narrate. I'm seeing 2 men approach the vehicle. I'm seeing them leave. 10 minutes later, I'm seeing 2 more men approach the vehicle and hand the passenger money. I'm seeing them leave. There you go. You just justified your reasonable suspicion, and you archived it on your video, and you'll be able to put it into your report, which is key when you come to these court hearings. If you want to use the Terry stop, read Terry versus Ohio. If you have that reasonable suspicion and you're going to make a detention, as in they're not under arrest, it's between reasonable suspicion and probable cause, and you need to, you pull them out of their car, or they're on the street and you think there's something suspicious going on, you can pat them down. For officer safety, it has to be done fairly immediately. You can't wait 5 to 10 minutes for somebody to show up and do a pat down. Your chance of worrying about officer safety is gone. If you're worried about officer safety, you have to do your pat down there for weapons. But it's not a pat down for drugs, so you can't pat down and stick your hand in somebody's pocket and go, well, I thought it was drugs and it was drugs. Well, it doesn't matter. Your pat down is for weapons. Now you can ask, do you have any drugs on you? And you pat them down, they might say, well, yeah, they don't want to get caught. They say, yeah, I have drugs on me. They just consented to it. They just offered it to you. All this to say that you should remember the 3 levels: consent, reasonable suspicion to make your investigatory stop, probable cause to make your arrest. And if you make an arrest, you can have a search incident to that arrest. Archive everything on your videos, audio, and also your police reports, because it will show up in court again. And you'll have somebody like me cross-examining you about some of the inconsistencies in your report, which will not look good in front of the judge. So make sure that you archive what you have for your reasonable suspicion, your articulable facts, and then for your probable cause. Take pictures, keep the evidence. It's crucial. It'll keep your convictions.